Hi, Max here with Frizzwoods, and in this video I'm going to talk to you a little bit about pat-downs, or as us lawyers call them, Terry Frisks. Let's talk about why they're called that. But first, I'm going to take you back, way back to the 1960s in downtown Cleveland. Two gentlemen are pacing in front of a department store window 24 times. A very experienced officer who knows the area well is watching them do that. Those two gentlemen meet up with a third man, and that officer conducts one of the most important pat-downs in U.S. criminal law history and finds a gun. That pat-down went all the way to the Supreme Court, who wrote the opinion in the Terry versus Ohio case. Now, normally, searches under the Fourth Amendment require a warrant, and occasionally, warrantless searches are justified, generally by probable cause. But there certainly was no crime that had occurred. Those two gentlemen could pace in front of that store as many times as they want. However, the officer was able to articulate that it was quite suspicious. And the search was limited to a pat-down, meaning they did not search the pockets or bag of these gentlemen. So the question became, is there a time when for officer safety and based upon reasonable suspicion, you may conduct a limited pat-down of a person? And the Supreme Court said yes. They said when that pat-down is supported by reasonable, articulable suspicion. And from there, courts across the U.S. have interpreted that to mean a lot of different things and include a lot of different types of pat-downs. Let's talk a little bit about it. Reasonable and articulable. What does that mean? That means that the officer must be able to come into court and articulate or explain what the reasonableness of the suspicion was. And then obviously suspicion. They need to come into court and testify what they thought was suspicious. And then a judge needs to decide, was that in fact reasonably suspicious? If they say that the gentleman was very tall and I suspect all tall men of having weapons, probably not. Now, if they say he was standing in a high crime area and nothing else, probably not. Now, if they say he was standing in a high crime area and I saw a bulge on his pants and he was wearing red and it's a Crip area and that's the gang in the area, maybe. These are calls that a judge has to make. And these are burdens that the state must meet. Because when your attorney challenges a warrantless search, like a pat-down is, then the state bears the burden of justifying it. What can they actually do? They should be allowed to frisk the exterior of your clothing. Sometimes you'll see the back of a hand. What they may not do is enter into a pocket. They may not open up your bag. They may not enter into your pants pockets. However, what if they do? Well, if they feel the weapon, then they may. But what if they feel something that is contraband or they think is contraband? Well, the courts have told them that it needs to be immediately recognizable. So the officer needs to be able to come to court and articulate how they immediately recognize the thing that they pulled out of your pocket was contraband. We often see with bullets that they may be able to say it's immediately recognizable. But if we're talking about a pill, it could just as easily have been a pebble. These are arguments that your attorney needs to make after the state tries to justify the search. So, if you've been the subject of a pat-down, and you think that it was excessive and not supported by reasonable articulable suspicion, then you should ask your lawyer to challenge that search. If you have a case and you'd like us to take a look at it, we're here in Maryland, we'd be happy to do that. If you have an attorney already, then I'm sure they already know the law on this. I wish you all the best with your case. Good luck.